Thank you, Committee.
Thank you. Next up, we have item 5, which is House Bill 38 by Representative Bulsell.
Thank you, Madam Chair. Members of the committee.
Thank you for being with us today.
Second.
Do we have a motion on the bill? Do I have a second?
Second. Yeah. Thank you.
You're
Madam Chair,
recognized.
this is a bill that seeks to vest in the Speaker of the House and the Speaker of the Senate the authority, should the need arise, to retain counsel in addition to the Attorney General to bring an action on behalf of Tennessee so long as the additional counsel does not result in an increase in state expenditures. And the background for this legislation is this. You know, we obviously know that the Attorney General typically has the authority to bring an action on behalf of the state of Tennessee. That is spelled out in Section 8-6-101 of our Tennessee Code. Interestingly, there's nothing in Article 6 of our state constitution that defines the role of the Attorney General, but this body has done that in 8-6-101. So typically you have the judicial branch bringing a case to enforce the rights of the state of Tennessee in court. Also, under 8-6-106, the governor is vested with the authority, should the need arise, to retain counsel in addition to the Attorney General to represent the state's interests. And I know that that power has been exercised over the years by some of our governors, because in 2001, Governor Sundquist actually asked me, pursuant to this statute, to represent the state in a case that was pending in federal court challenging the constitutionality of part of our optometry code. And then in 2013, in a related matter, Governor Haslam, pursuant to the same statute, asked me to do the same thing. But we don't have any commensurate authority in the legislative branch to bring an action in court to represent the state of Tennessee should the need arise. And many of you are aware, many of you were here several years ago when there was a joint resolution passed by both houses that authorized retaining outside counsel to represent the state against the Department of the State of the federal government in an action involving refugee resettlement. And ultimately, that action was dismissed on standing grounds, both in the district court and in the Sixth Circuit Court of Appeals, because according to the court, there simply was no legislative authority for the General Assembly to retain its own counsel and to bring a case. This bill would fill that gap. It would effectively put the legislative branch on the same footing as the co-equal branches of government. It would obviously allow the legislative branch, pursuant to 8-6-106, to bring a case should the need arise in the judgment of the Speaker of the House and the Lieutenant Governor. Obviously, the Governor's got this authority already under 8-6-106, and the Attorney General has it under 8-6-106. So that, Madam Chair, is a summary of the reason for this bill and the need for it.
Thank you so much for that explanation of your bill. We do have some questions. Representative Powers.
Yes, if I ever need a lawyer, I'm going to hire him.
I would think so.
He did such a good job in my office that I signed on to his bill. So I just wanted to say that I support your bill, and thank you for bringing this forward.
Thank you.
Any other questions? Yes, Representative Dixie.
Thank you, Chair. I guess my question is that if the governor and the attorney general can already bring this, why does the Speaker of the House and the Lieutenant Governor need the same authority?
Well,
Oh, we all got it. Sorry. Apparently you set off some alarms.
Continue.
Thank you, Madam Chair. The need is there because we saw in the refugee resettlement litigation that the courts will not allow the General Assembly to assert rights that exist under the Tennessee Constitution. That was the ruling of both the Federal District Court and the Sixth Circuit Court of Appeals. So there's a need to put the legislative branch on the same footing as the other two branches of government. There may be occasions where the Attorney General's office, for whatever reason, is not able to represent the state. And as I mentioned, in my own personal legal experience, that's happened twice. Once in a very significant case, as I mentioned, in federal court, where the constitutionality of one of our optometry laws was being attacked as a violation of what's called the dormant aspect of the Commerce Clause of the U.S. Constitution, Article 1, Section 8 of the Constitution. So we've got the dynamic where the governor has got the ability to retain counsel, the judicial branch has the ability, but there is no corresponding ability in the General Assembly. This bill fills that gap.
Yes, Representative Dixie.
All right. So I guess that my point is that even in the past, this situation has arisen, and we've been able to work around it. My fear is that, and you can correct me if I'm wrong, if that Attorney General that says, okay, like with the refugee issue, let's say if AG was like, well, I don't think that's something that I want to, we should get involved in or whatever. Now you're saying that that the General Assembly can force action on its own without the
Yes, the effect of this legislation, if passed, would be to allow the General Assembly to retain counsel without the Attorney General's involvement.
Right. So I think there's the point of like having these different branches and these checks and balances is for a reason. I think that we keep coming up with more and more power for the General Assembly, and I don't think that's what it was intended to do. I think the point of it is we can work together and come to a compromise, but you can't, just because one Attorney General or the governor says, all right, I don't think we should do this, we should have another workaround over here to say, well, we do. There has to be some balance and check and balances there. The way that we're moving here in this General Assembly seems to be pressing the foot on the gas that one day could come back and bite us, and I'm just a little hesitant about supporting this bill in its current form.
If I might respectfully, Representative Dixie, the reason for this bill is because the General Assembly does have the constitutional authority to determine who represents the state of Tennessee in both state and federal courts. It was this body years ago in 8-6-101 that vested in the Attorney General the exclusive right to bring cases and defend cases on behalf of the state of Tennessee. This body then gave a part of that power to the governor pursuant to 8-6-106. This body has never actually given that power to itself, which is what this bill does. And the failure of the statute of 8-6-106 to give the General Assembly this authority did come back to bite the state of Tennessee when the action filed by the General Assembly regarding refugee resettlement was dismissed for the express reason that there was no statutory authorization for the case. So respectfully, there is a need for this, and if it's not passed, we will have still this unequal balance where you've got two branches of government being able to defend and represent the state of Tennessee's interests in court, but no corresponding ability by the General Assembly.
One last follow-up.
One more?
Excuse me. Sorry, I got choked up there for a second. And I just kind of want to go back because it sounds like you're saying that the General Assembly has this power already. They gave some of the power to the governor, but we don't have the power. So I guess I'm confused, but if we already have the power to do this, I don't see the need for this bill. And that's just my understanding, or maybe lack of understanding of it. But maybe I'm having a hard time following, and we can talk at a later date, because I know we didn't get a chance to speak before this. So that was just my last comment.
Any more questions for our sponsor? Yes, Chairman Kiesling.
Thank you, Madam. But that is the intent, isn't it, Representative? It is to go back to return that to us, then, the legislature. That's the intent, your intent for this whole thing. So give us put this in. Okay, you've been using the refugee resettlement as an example. What are others? Can you just briefly give us some other situation or example that to put it in a little more perspective for some of us? Certainly me. I'm still out in a little bit of fog here.
Sure.
I've only got a quarter of a mile of distance ahead of me, so I'm still a little foggy here. Can you open it up for me just a little bit more?
I sure can, Mr. Chairman. Let me do it in this manner, because I think looking at the long game here is
Yeah.
probably helpful, because right now, if in fact the bill were to pass, it would authorize the Speaker of the House and the Speaker of the Senate to retain counsel to represent the state in federal court to defend the state of Tennessee's constitutional rights. And if this were to pass, my intention would be to approach Speaker Sexton, Lieutenant Governor McNally, and using the statute to authorize Tennessee to file an action under the 10th Amendment in order to bring into line the out-of-control federal spending and federal overreach, which is adversely affecting
Right.
not only Tennessee, but many other states. And right now, there's no ability for the General Assembly to do this. And there's a need and there's a way to do it, because right now, we have a federal government that's out of control. There are no brakes, there are no guardrails. And when we look at Tennessee's rights under the 10th Amendment, it's clear that our founders determined that our government, our federal government, was only a government of limited rights. That is, only those that were expressly granted in the Constitution. And yet, since 1936, when our Supreme Court decided the Butler case, the federal government has both grown in breadth, in reach, in spending, and in taxation. And what this would allow us to do, if adopted, would be to file a case under what's called the original jurisdiction of the U.S. Supreme Court, Article 3, Section 2.
And what's that now, then?
The original jurisdiction? Yeah. Most of the cases that get...
Now, don't get in the weeds on me.
I won't. Okay.
Okay.
In order to get to the Supreme Court, typically you've got to go from the district court, federal district court, to a federal circuit court of appeals, to
Okay.
the Supreme Court. But there's a narrow set of cases that the Constitution allows to be brought directly in the U.S. Supreme Court. One of those classes of cases is a case between a state and the federal government. This would be such a case because it would be brought by the state of Tennessee to enforce its rights under the 10th Amendment to give us the limited government that the founders intended.
Okay.
And specifically, it would raise the issue of whether the federal government has exceeded its power under what's called the General Welfare Clause. And not to get into the weeds, Mr. Chairman, but our federal government constitutionally can only spend money on three things. One is the debt, one is to defend the country, and the third is to provide for what's called the general welfare, which was a term of art in the 18th century. And James Madison wrote about it in Federalist Number 41, where he talks about the fact that the federal government can only tax and spend with regard to the powers that are enumerated in Article 1, Section 8 of the Constitution. And that was actually the way that the Supreme Court interpreted the Constitution until 1936, when the Supreme Court very intentionally went away from James Madison's own interpretation of the Constitution he wrote and instead adopted another view that held that the General Welfare Clause was itself an additional grant of power and authority to the federal government. And the plan would be to bring the case under this original jurisdiction of the U.S. Supreme Court and request those 5 wonderful constitutional conservatives we have there, plus John Roberts, to go back to the way James Madison interpreted the Constitution that he wrote. That's how this would be used if it were passed, Mr. Chairman.
Thank you. Thank you very much. Well said, and it is a little more clear for me. And I really appreciate, again, you bringing us. Certainly, I'll be supporting this. Thank you, sir.
Thanks, Mr. Chairman.
Thank you. Thank you, Madam Chair.
You're welcome. Do we have any more questions? Questions been called. All in favor signify by saying aye. Aye. Those opposed, no. The ayes have it.
Okay. Thank you, Madam Chair.
That brings us to the end of our calendar. No further business before this committee. So do I have a motion to adjourn? We are adjourned.